Super. Well, good afternoon to everyone who is joining us on this Friday afternoon. And for anybody that I've not had the opportunity to say Happy New Year to, I will say Happy New Year at this time. I'm Malcolm McNeil. You know me as your president-elect of the Beverly Hills Bar Association. And I couldn't be more pleased and happy and personally satisfied that we're bringing to the BHBA members the experience that we have for our current guest. Our guest today is Lawrence S. Ebner, aka Larry Ebner. He brings about 50 years of litigation knowledge and experience to the table, and he is also the executive vice president and general counsel of the Atlantic Legal Foundation. I've had the privilege to meet Larry and to speak with Larry and talk about heady legal issues, as I'm a board member of the ALF, or Atlantic Legal Foundation. And Larry joined us last year in 2020 to take over the role of basically reviewing and monitoring and analyzing cases that might be considered for possible ALF amicus participation. It's Larry's job to review ALF amicus support and whether or not it's an issue we wish to take up. And he personally authors the ALF's amicus briefs to the Supreme Court, to the federal courts of appeal, and the state appellate courts. Just a little bit about his background. He's a Harvard Law School graduate. He was in private practice up through 2015. He presently also has a side job of maintaining his own practice as appellate practice while also fulfilling the duties with ALF. He is a prolific writer, a speaker on a broad range of topics, and I could go on and on. He's a member of the American Academy of Appellate Lawyers. He's also a member of the prestigious Federation of Defense and Corporate Counsel. He's the vice chair of the Center for Law and Public Policy, and on and on and on. But you can check out Larry's bio both at his law practice and at the ALF website. So without further ado, I want to say, Larry, welcome to the program this afternoon, and thank you so much for accepting the invitation.
Well, thank you, Malcolm. I'm delighted to join you.
Thank you so much. I'm not sure of what level of experience our attendees and listeners may have for the program. So I guess I'd like to start with some basics for the benefit of everyone, including me. We all hear the term amicus used, and sometimes we hear amicus used. And I guess that one of my primary questions, because we don't want to look foolish in court, is there a correct pronunciation for an amicus brief or an amicus brief?
Well, I'm not a Latin scholar. I would say about 2/3 of the folks I know who are appellate lawyers say amicus. The other third say amicus. And I believe Justice Breyer calls it amicus briefs. But I like to say amicus, but you're welcome to call it either.
Thank you for that.
Amicus curiae, friend of the court.
Okay, amicus curiae. I will remember that. And I think we can start with one of the basics. I mean, the starting point is going to be, for the benefit of all of us, what types of organizations and individuals file amicus briefs?
Most typically, industry trade associations, public interest advocacy groups, nonprofits, in other words, professional organizations, including voluntary bar associations. I understand Beverly Hills Bar Association has its own amicus committee and occasionally files amicus briefs. And also sometimes ad hoc groups of individuals, such as scientists, or with increasing frequency, law professors, and sometimes government officials in their individual capacities, such as a group of members of Congress. In addition to that, governmental entities file amicus briefs. The United States, individual states through their attorney general offices, and sometimes local governments. So those would be the most typical amicus filers. And let me just say that they were normally filed in appellate courts, the U.S. Supreme Court, federal courts of appeals, and state appellate courts.
Well, I was just about to ask that question because I think what gets the most publicity, or at least with the general public, are the filings with the Supreme Court, and we hear about amicus filings. But does it ever make sense to file amicus briefs at the federal or state trial court level? And what would the considerations be to make that determination?
I would say it's uncommon for amicus briefs to be filed at the trial court level. There are exceptions, and one exception is in Washington, D.C., where the U.S. District Court for the District of Columbia actually has a local rule on the filing of amicus briefs. I would say that if amicus briefs are filed at the trial court level, it would normally be at the summary judgment stage, and it would normally be by a group that has not only an interest, but a special interest in the litigation, but almost always in the appellate courts.
I didn't point out in the beginning, but I will now, that your practice is in Washington, D.C., and I think that's where
Yes.
you've had most of your practice.
Yes.
And as you know, we are the Beverly Hills Bar Association, and the majority of our members are California-based lawyers. So could you opine a bit on what the key rules would be here on filing amicus briefs on the merits in, for example, the California Supreme Court and then perhaps the Court of Appeal?
Sure. Well, let's start with the California Supreme Court. There were really two different opportunities to file amicus submissions in the California Supreme Court. First, when a petition for review is filed in the California Supreme Court, the rules allow for the filing of what are called amicus letters. The amicus, it can be anywhere from 1 page to 3 pages or longer. Anyone can file an amicus letter. Don't even have to be a lawyer. And the purpose of an amicus letter is to explain to the court why it either should or should not accept review. They are addressed to the Chief Justice and the Associate Justices of the California Supreme Court. They're not placed on the docket, but I understand from my own experience drafting such letters that they are important in the court's consideration on whether to take up a case on the merits. When the California Supreme Court does grant review, then there is an opportunity for amicus curiae briefs supporting one side or the other, and there are rules regarding timing and so forth. In order to file an amicus brief in the California Supreme Court, it's necessary to file a motion for leave and obtain the court's permission, which is routinely granted as long as the request is timely. Normally, the proposed amicus brief accompanies the motion for leave. Similarly, in the California Court of Appeal, there's an opportunity to file amicus briefs on the merits of an appeal.
I've heard it both ways about whether or not the courts enjoy receiving amicus briefs, or at least find them helpful in determining an issue. Some have said the courts don't want to be bothered or they ignore them, and others have said they welcome them and they invite them because it helps to inform on the issues. What is your experience and your opinion on that?
My experience over the course of the last 20 years or so in watching amicus practice evolve is that now amicus briefs are a common practice in federal courts and state courts, and for the most part they are welcomed as long as they are timely, and most importantly that they do not duplicate the arguments, the legal arguments of the parties that the amicus brief is supporting. They serve important functions by providing an appellate court with additional legal argument or additional factual information, sometimes technical information that bear on the legal issues being considered by the appellate court. And if I can say, Malcolm, they also serve another important function from the viewpoint of the organization submitting the brief. Amicus briefs provide trade associations, advocacy groups, professional organizations, and so forth, a direct voice in the U.S. Supreme Court or the federal courts of appeals or state appellate courts on legal issues that are important to them and their members and their supporters. And for the benefit of the attorneys who are listening to this webinar, they also provide an opportunity for lawyers to play a role, to use their brief writing skills and to perhaps become better known to the appellate courts through the submission of amicus briefs.
Well, you raised an interesting point in that answer when you said that that we can bring additional information, and those of us who have had the opportunity to file appellate briefs know how strict some of the courts are on the record and what's in the record below. So I guess my question there is, how far can or should an amicus brief go if it wants to present facts of the court that are outside of the record below?
Well, I need to draw a distinction, as I think the courts do, between adjudicatory facts and legislative facts. Adjudicatory facts are the facts that are pertinent to the case before the court. And of course, appellate courts are limited to the record on appeal, and it would be improper, at least inappropriate, for an amicus curiae to provide adjudicatory facts that are outside the record. On the other hand, it's commonplace to provide legislative facts. Now, the term legislative facts is a broad term, but maybe the classic example is where an industry trade association files an amicus brief and discusses the impact of the issue or of the lower court's ruling on the industry as a whole, or on the public, or both, rather than just its importance to the actual litigating parties. So the other thing I'd like to say, and maybe we'll get into drafting amicus briefs a little later, but I think it's important for an amicus brief not to get bogged down into the facts of a case, into the adjudicative facts. As everyone knows, when you submit an appellate brief, you need to include a statement of facts. And it's a waste of space and probably a waste of time and an unnecessary distraction to do anything more than provide a superficial description of the facts of the case, and only if necessary to the legal arguments that are being presented in the amicus brief.
So would it be fair to say that it is more helpful for the briefs to address public policy issues over and above the facts? I think that's the implicit comment there. And as long as those public policy issues, I take it, are relevant to the issues being decided between the parties.
Yes, I think that's a fair statement. One thing to keep in mind is that there are a certain set of legal issues in the U.S. Supreme Court. It's the questions presented that the court is considering. And it happens sometimes, but it's normally not appropriate for an amicus brief to try to interject into an appeal an issue that is not before the court. However, it's perfectly appropriate and desirable to provide additional perspective, legal perspective or policy perspective, or both, on the legal issues before the court. This is particularly true at the certiorari petition stage in the U.S. Supreme Court and at the petition for review stage in the California Supreme Court. So yes, policy points are important, but normally they should be coupled with legal argumentation.
It's interesting because I've been reading recently in preparation for this about dueling amicus briefs, and I guess my threshold question is if an amicus brief's been filed against a party that we represent, is it better to address the other brief? Is it appropriate to address the other brief, or is it better to ignore it?
For the party itself or for an amicus?
Well, I'm thinking that that one part, somebody's filed an amicus brief, for example, on the case, and we're filing a competing amicus brief on the other side. Should
Yes.
we comment in our amicus brief about the one that's been filed, or should we simply present our points and ignore that other brief?
No, I do think that when amicus briefs are filed on the merits in an appeal, there sometimes are dueling amicus briefs, including when you have ad hoc coalitions of scientists filing amicus briefs to present different viewpoints, or if there are individual government officials filing amicus briefs to provide different policy perspectives. Let me give you a caveat to that. In the US Supreme Court, at the petition stage, in other words, while a petition for a writ of certiorari is pending, asking the Supreme Court to hear an appeal, it's normal practice to file one or more amicus briefs in support of the petition, but the conventional wisdom is not to file an amicus brief in opposition to a cert petition, because that would just call more attention to the petition. A couple thousand petitions are filed every year. And if you are a party opposing certiorari, you want the cert petition that you're opposing to be kind of lost in the crowd, not to be given extra emphasis. The exception to that would be when the US government or other governmental entities file amicus briefs, in which case, if they oppose review, they will file an amicus brief that explains why.
If an organization files an amicus brief that supports, say, one of its members or a financial contributor, is it required, or should it be the case that it be disclosed in the brief?
There's no requirement that I'm aware of that a organization disclose that the party it's supporting is either a member or a financial supporter. That fact, however, sometimes will be pointed out by the other side, and the amicus organization will be accused by the other side of just being, a mouthpiece for the party that it's supporting. There are ethical rules that started with the US Supreme Court and now have been adopted by the federal courts of appeals and state appellate courts, including in California, which basically say that an amicus brief cannot be financed or written in whole or part by a party to the litigation or its attorneys. And in fact, the rules require the lawyer submitting the amicus brief to certify that the brief has not been written in whole or part by a party or its counsel or financed by a party.
Interesting. Well, I guess that goes to the next question, because, well, I'll save that because I do want to get onto some drafting points in a moment. But can you describe for everyone what are California Supreme Court amicus letters? And more importantly, after we have that description, how are they used?
Used by the court?
Yes.
Well, the amicus letters are used by the court, at least by the law clerks working for the court, as I understand it, to assess the importance of a case or the legal questions presented in a case. And there are often dueling amicus letters for or against the granting of review in the California Supreme Court. In terms of amicus briefs, and I can generalize with respect to the US Supreme Court as well as the California appellate courts. They are read at least by the law clerks. When there are multiple amicus briefs filed, they are summarized by the law clerks, federal and state levels, for the justices, and sometimes read by the justices, and most importantly, sometimes quoted in opinions by the appellate courts. So they definitely play an important role from the court's viewpoint. In some smaller states, for example, New England states such as Massachusetts and New Hampshire, where the state Supreme Courts don't have the deep bench of law clerks that larger states have, the courts will actually, on their websites, solicit amicus briefs on particular legal issues that they need to address in a particular case, to provide them with useful research and argumentation that they may not get from the litigating parties. So they definitely play an important role. One last point. I think somebody took a survey a few years ago of the role of search stage amicus briefs in the US Supreme Court. And you can take this statistic with a grain of salt. I don't quite believe it, but the survey indicated that a cert petition that is supported by one or more amicus briefs is 6 times more likely to be granted by the Supreme Court than one that has no amicus support. And I can tell you from my own experience that while it happens sometimes, including this term in the Supreme Court, typically every case that is granted review has been supported at the petition stage by at least one amicus brief, and sometimes by multiple amicus briefs.
Interesting. Well, I'm concerned. I draft, if I don't draft my own pleadings, I end up reviewing them and putting my appropriate finishing touches on them. So I guess one of my questions as a writer is, what are some of the key do's and don'ts for, let's say, amicus briefs in terms of how the tone and the style, how aggressive should they be, or how law scholarly should they be? What's your experience?
Well, we appellate lawyers like to think and say that amicus briefs are different than trial court briefs, just like appellate briefs in general are different than trial court briefs. They may address the same legal issues, but the tone is often different. So the advice I like to give for amicus briefs, I guess I have several pointers. One of them is to keep the brief as short as possible. In the US Supreme Court at the search stage, there's a 6,000 word limit. The ones that I write are rarely more than 4,000 words. If you know that there are multiple amicus briefs that are going to be written, you want yours to be read, so you need to keep it as concise as possible. Every amicus brief in any court has to begin with a section that's called something like interest of the amicus curiae. And many times inexperienced amicus brief writers will, if they're, let's say they're representing a trade association, they'll go to the association's website to the about section and copy the paragraph that describes the association, what it does, and use that as for the interest of the amicus curiae section. Now that's fine, and it's important and appropriate to do. My own view is that the interest of the amicus section should do more. It should engage the reader right up front. So to make the reader, whether it's a law clerk or a justice or a court of appeals judge or all of them, to want to read the entire brief. So you engage the court after the boilerplate paragraph about who the amicus party is by explaining in some detail what the interest of the amicus party or parties is, why they are submitting this amicus brief. It may be because the legal issue affects an entire industry. It may be because, and the association or other organization has a special expertise on the subject matter of the case, uh, and wants to provide that court with that additional information or perspective, or whatever it may be. It's important to engage the court right up front. So pay attention to the interest of the amicus curiae section. I've already said that it's important not to get bogged down into the specific facts of the case unless the facts are really important to your legal argument. And I've also said, stick to the questions presented. In most cases, don't try to interject additional legal issues that have not been raised by the parties. You may be hurting the party you're supporting rather than helping them. And I think if there's one point that the participants in this webinar take away from my comments, it's this: an amicus brief should not replicate the legal arguments that have already been raised by the party that the amicus brief is supporting, and to the extent possible, not replicate the arguments in other amicus briefs. Nobody wants to read a Me Too amicus brief. And sometimes it's very difficult to come up with different arguments, which is why often, at least at the US Supreme Court level, you will see, and here's another Latin word for you, Malcolm, you'll see multiple amici curiae filing a joint amicus brief because they want to band together to provide a certain legal argument. And if you look, for example, at Supreme Court, the Supreme Court rules 37.1, which is the US Supreme Court rule on amicus briefs, it says basically that amicus briefs that provide additional information are appreciated. And some courts of appeals in their local rules state flat out, don't duplicate the arguments that already have been raised. As far as the tone is concerned, it's hard to explain exactly what I mean, but the amicus brief should have a somewhat elevated and restrained tone. It should not get into ad hominem attacks, for example, on any of the parties. The amicus brief is one step above and beyond the brief of the party, of the actual litigants in the case. So it's kind of a treat to be able to have that kind of one step removed position in the amicus brief and adopt an elevated and restrained tone.
You caused me to actually think about a few things when you talked about that new Latin word amici, okay? And I guess my question is, I was thinking about it, and in light of your comment that make sure you don't just repeat what other people have said and get involved in a Me Too brief. So with those thoughts in mind, how far, if a client comes to you and says, I want to file a brief, are there restrictions on my contacting other amicus counsel to coordinate our efforts? Are there restrictions on if I see an issue that looks like something a client or a non-client should handle? Are there restrictions on soliciting the client to participate at the amicus level?
There are no restrictions on soliciting amicus briefs. It happens all the time, particularly in the US Supreme Court. And there are, as I mentioned, an amicus brief needs to certify that the brief has not been written in whole or part by the supported party. But it's common practice, and I certainly follow this practice, of providing a near final draft of my amicus brief to the party I'm supporting, not for review per se, but share it for them to read and let me know if I'm saying anything that conflicts with their positions or undermines their positions. If I get back, and this doesn't happen too often, but it has happened to me. If I get back a significantly redlined version of the near final draft that I've submitted, I will not read the red line. I just won't look at it because I want to be able to certify to the court with a clear head that the brief has not been written in whole or part. You know, if there's a word here or there, then that's okay. Now, in terms of soliciting and coordinating amicus briefs, if you look at the comments on the Federal Rules of Appellate Procedure, where they added the certification requirement several years ago, one of the comments is that it's okay to coordinate the submission of amicus briefs, and that really benefits the appellate court. If I am the lawyer who has just filed a cert petition or plans to file a cert petition, and I want amicus support, I don't want a bunch of V2 amicus briefs. I may have in mind certain amicus topics that I think would be appropriate for amicus briefs. For example, if it's a case involving statutory construction, it may be appropriate for an amicus brief to dig into the legislative history, something that I may not have done in my cert petition. It may be appropriate for another group to address another legal argument, maybe in the anticipation of what the opposition to certiorari will say. So it's fine to suggest amicus topics. It's not fine, again, to write an amicus brief for an amicus party if you're the actual litigating party or the attorney for the litigating party.
Well, with that in mind, could you give, for the benefit of those attendees who may not be familiar with it, a little bit of a background or explanation of the Supreme Court Rule 37.6?
Yeah, well, 37.6 is the disclosure requirement that I've mentioned, and the genesis of it, the rationale for it, is that the Supreme Court did not want litigating parties of the petitioner or the respondent, in other words, in the U.S. Supreme Court, to use amicus briefs as page extensions. And I guess I've only seen it happen, you know, maybe a couple times over the course of, I don't know how many decades, but I guess in the past, some parties will actually draft an amicus brief and try to shop it around to organizations and get them to submit it. And that's the rationale for that. And similarly for the same disclosure rule. So when you read this language carefully of 37.6 and its counterparts in the lower courts, it's not a flat out prohibition. It's a certification that it hasn't been done. And the theory, which I think is a very good theory as a practical matter, is that it's a strong deterrent. You know, if I were to submit an amicus brief saying, well, yeah, this was, you know, half of it was written by the party I'm supporting, the brief is not going to have any credibility and it's not going to be written or paid for by the amicus party.
Well,
I'm sorry, excuse me, paid for by the supported party.
Understood. Well, I guess with that, for the benefit of those of us who have had limited experience with filing amicus briefs, could you give us a rundown of, say, some of the procedural pitfalls that might trip up a new filer to the Supreme Court for amicus briefs? I mean, notices, deadlines, things that might cause us embarrassment or worse.
Right. For petition stage amicus briefs, in other words, amicus briefs that support petitions for writs of certiorari, there are two key rules. The first rule is that amicus briefs supporting a cert petition are due 30 days after the case is docketed. Now, what happens is cert petitions have to be printed unless it's a pro se petition. And so it gets filed and it takes a few days, particularly these days, for the case to be screened and actually docketed. It may take 2 or 3 days or sometimes longer if there's a holiday weekend. And so the 30-day clock begins to run when it's docketed, and it's very easy to find out. You can go to the Supreme Court website, do a docket search, search for the name of the case, see what the case docket number is, if it's been docketed, what the docket number is, and it will say right there, it'll do the counting of the 30 days for you and tell you what the deadline is for the brief in opposition, the respondent's brief, which is also the deadline for amicus briefs. Now, let me say there's a second rule, and then I'm going to loop back to the first rule about the time period. The second rule, which trips up a lot of lawyers who haven't filed too many amicus briefs, is the 10-day advance notification rule. An attorney who intends to file an amicus brief needs to notify the counsel of record for both parties, the petitioner and the respondent. This is at the cert petition stage, of its intention to file the amicus brief, and needs to do that at least 10 days in advance. And the reason for that rule is really to give notice to the respondent, to the party opposing cert, that one or more amicus briefs are coming, and to give them an opportunity to request an extension of time. Because normally the respondent will have the same 30 days from when the petition is docketed that the amicus party will. But if you're representing the respondent, it's easy to get an extension of time, at least 30 days, except in very unusual circumstances. So that's the reason for the notification requirement. I said I was going to loop back to the deadline rule. Sometimes a respondent, rather than filing a brief in opposition to the cert petition, will notify the court that it is waiving its right to file an opposition. And the court receives that notice and either will go ahead and look at the cert petition and deny it, or it will request that the respondent, despite its waiver, go ahead and file an opposition brief or a response to the cert petition. And when that happens, that starts the 30-day clock again. And the amicus briefs are then due, or at least the ones that have not been filed in accordance with the original deadline, they'll be due when the respondent's brief is due on that extended deadline. But that's an unusual circumstance. So those are the key rules: the 30-day clock and the advance notification requirement. There's a third rule that's important, which is consent. It is almost always the case that both sides, both the petitioner and the respondent, will consent to the filing of amicus briefs. Sometimes they'll lodge with the clerk of the court blanket consents, or they will respond by email. I'll send an email to the counsel for both sides and say, I intend, given the advance notice, I intend to file an amicus brief for the Atlantic Legal Foundation. Will you please consent to the filing of the brief? It is quite unusual, and I would say, since you're wearing the jacket that you're wearing, I'll say it's Bush League for the respondent to oppose a request for consent. It doesn't mean that the respondent is agreeing with what is going to be in the amicus brief. But I'm not aware of any circumstances where the Supreme Court, when a motion is filed in lieu of receiving consent, has denied a motion for leave to file the amicus brief, as long as it's submitted in a timely fashion and complies with all the other format rules that the court imposes.
Wait, but you raise an interesting question. What's the best way to respond if an opposing party objects to or holds back consent for an amicus brief that you want to file? How do you respond to that?
Well, my first move will be to speak with the petitioner's counsel and ask the counsel, what's up with your opposing counsel? Can you call this lawyer and talk some sense into them? Because they're going to look bad if I, under the rules, if I don't have both sides consent, I have to file a motion for leave, which is part of the printed booklet that is also composed of the amicus brief itself. That'll tell you something about how often the Supreme Court denies leave, which is never, as long as it's timely submitted. So it happens, but it normally happens by attorneys who are not very experienced in Supreme Court practice. Now, as I think I mentioned earlier, in the California courts, my understanding could be wrong, but the way I read the rules is you have to file a motion for leave accompanied by the proposed brief. And nobody wants to take the time, spend the money drafting an amicus brief, attach it to a motion, then have that motion for leave denied. It does happen sometimes in the federal courts of appeals. And in fact, the U.S. Court of Appeals for the Seventh Circuit is notorious for turning down requests for permission to file amicus briefs. They really want to see an amicus brief that adds something that doesn't duplicate the supported parties' arguments and so forth.
Excellent. Can you, and lastly, on practice pointers, can you give us a little overview of what might be some of the, let's say, no-nos regarding format or typography mistakes that might be made in connection with the briefs? I know our practitioners who are getting started, we all have the paranoia that we're either missing a rule or doing something wrong. What have you seen in your practice that look like the worst mistakes?
Well, first of all, on the U.S. Supreme Court level, and also in federal courts of appeals, including the Ninth Circuit, there are rules about format. For example, in the U.S. Supreme Court, Century School Book with 12-point font is the way that cert petitions and amicus briefs are prepared, except if it's a pro se type situation or someone who's incarcerated or in a form of pauperous type situation. And you need to know all the nuances. That first footnote that gives the certification that the party hasn't written, it's got to be in 10-point font. So, you hate to spend the money printing up an amicus brief and have it sent back. That normally doesn't happen because the printer knows what the rules are. there are also rules about the color of the cover for different types of briefs in the Supreme Court.
What's the color for an appellate brief, or excuse me, for an amicus brief?
At the petition stage, that's the color, tan.
Okay.
And what happens is that I would say that, there are a lot of theories about formatting briefs, both in the, appellate briefs, both in the Supreme Court and federal courts of appeals and state Supreme Courts and state appellate courts. Personally, I like very short argument headings. I like some level of argument headings. And I'm with the school of thought that you don't use all caps. I mean, I've heard any number of talks, including by judges, saying that all caps, even for Roman numeral argument headings, are difficult to read. Particularly since most judges these days read briefs on computer screens or iPads. And so my own practice is to use initial caps for major argument headings and initial cap only the first word for subheadings. I know we're really getting into the minutiae here of format, but the idea, of course, is that you want your brief to be readable from a visual and graphic viewpoint. So I like keeping it clean. And that also leads to a comment I have about the table of contents. I think that most judges and law clerks, when they look at any appellate brief, including an amicus brief, are going to look at the table of contents, eyeball that and see what the brief says. And so I think it's important to use those rules about making the argument headings short and readable and not clutter them up too much. There are also requirements for citation of cases. And I know in California, and I've never gotten used to this, you put the year in parentheses before the citation. Don't understand that, but I've done that, when I've written California briefs. But the normal blue book citation format is what normally is used, including italicizing case names rather than underlining them.
Larry, I'm just keeping an eye on the time here, but there are a couple of other marketing issues that I wanted to discuss with you, because many of our practitioners in the BHBA are either solo or small firm lawyers. And one of the first questions that always comes up with clients are fees. How much is it going to cost? And I would like to talk a little bit about that. What are the pros and cons in the, let's say, in the amicus realm over flat fee versus hourly billing? What's the norm? Does a client set up a budget with you and say, I want to spend $15,000, or do they want to do it hourly? I mean, give us a little bit of insight on that.
Well, first of all, mid-size and smaller law firms and solo practitioners, I think, have an advantage when it comes to appellate litigation fees in general, including with respect to amicus briefs, because I think they can be more flexible and use flat fee arrangements than larger firms that have large appellate departments and maybe, have a team of lawyers working on an amicus brief, each billing by the hour. So I personally am a fan of flat fee billing. I think that flat fee billing works very well with amicus briefs because it's a single project. It's one brief. And if you want me to be more specific, I would say that in most cases, for a US Supreme Court amicus brief, and probably for a federal Court of Appeals brief, a flat fee somewhere in the range of $10,000 to $20,000 would be typical.
Well, I guess that leads to the next question, and I also want to leave a few minutes at the end to talk about the ALF. But what are some of the ways that an attorney can use the briefs to promote their practice? I take it there we can use them as an effective marketing tool to show what we're doing and what areas of the law we're in. But what's your experience?
Yes, well, my experience is that that when an attorney writes an amicus brief, it's an excellent uh, practice development tool, and I would refer the webinar participants to the Atlantic Legal Foundation's website, atlanticlegal.org, where we have case summaries, and you can access all of our amicus briefs, current and prior, and also to my own website, capitalappellate.com, where I use the amicus briefs as part of the website. I think that it's common for a lawyer who's written an amicus brief to send it out to clients or potential clients that might be interested in the legal issue, or to know that the attorney has written an amicus brief. Important to put it on your own website. And it's an excellent marketing tool, and I think it's a mistake just to file a brief with the court and then throw it into a filing cabinet and do nothing else with it. There's one other really important point that I forgot to mention, if I could just backtrack,
Sure.
which is that, and this is for the benefit of the viewers who might be handling an appeal and are looking for amicus support. My strong advice is to think about amicus briefs well in advance of when the brief is due, and to reach out to potential amicus counsel or amicus filers and ask them to consider. Virtually every organization that files amicus briefs has some internal mechanism for reviewing requests and deciding whether to file. And when an attorney files a cert petition and the 30-day clock starts to run, and then as maybe an afterthought says, well, gee, maybe I ought to look for some amicus support, that's a practical matter. It's very often too late, particularly if you're talking about an organization that has an internal amicus review process. So if you know you're going to file a cert petition, if you know you're going to file a review petition, if you know you're going to file a merits brief in a lower appellate court, and you're interested in amicus support, reach out to potential amici as far in advance as you can.
And to our attendees, I just wanted to say at the outset, I didn't invite Q&A because I knew that we had so much material that we might have to do a part 2 to this. And I want to thank Larry at this moment for his participation. But I have a couple of more questions that I'd like to ask you. But if anybody does have any questions that they'd like to ask, give them to us, and we'll either respond during the program, or I'm sure that Larry would be happy to respond after the program is over via email or otherwise. But my last question is that we talked about it. I told you that I'm a board member of the Atlantic Legal Foundation. You're the EVP and General Counsel, and you're the what I'll call the bottleneck to deciding what gets what issues we take up, etc. So tell us a little bit about the Atlantic Legal Foundation's Amicus Brief program, how it works.
I'd be happy to do that, and also encourage any of the viewers of the webinar who were involved in appeals to contact us if you think that you're handling in a case involving legal issues that fall into one of our 6 mission areas. Our advocacy mission areas are individual liberty, free enterprise, protection of property rights, limited and efficient government, and maybe our 2 hallmark areas that make us somewhat unique from other public interest law firm advocacy groups, advocating for sound science in judicial and regulatory proceedings, and advocating for school choice. So if you have an appeal involving legal issues that implicate one or more of those areas, uh, let me know, and we'll send you our amicus request form to fill out and help educate us about your appeal and facilitate our process of deciding where to file an amicus brief.
So that's that. So if our attendees know of a case that falls within any one of those realms, they should visit the site, get the form and submit it, and see if it's something that we feel is within the purview of the ALF's mission. Is that fair to
And
say?
I should say that the Atlantic Legal Foundation, its name notwithstanding, is a nationwide, non-profit, nonpartisan, public interest law firm. We file amicus briefs all over the country, including in the Ninth Circuit and the California Supreme Court. And in fact, Malcolm, you're one member of a substantial West Coast contingent of Atlantic Legal Foundation leadership.
We recently had one of our board members appointed by the Biden administration to a position. Is that right?
Yes, as the U.S. Attorney for New Jersey,
And who is that?
Phil Selinger.
Yes, yes. I wanted to bring that up because it demonstrates that our board is populated with a wide variety of views, which make our board meetings quite interesting, and the decision-making process internally is quite cohesive. I think it's a good example of bipartisan cooperation among the board, which is one of the reasons why I enjoyed being a member of the board.
Yes, for sure.
So let me check real quick and see. We're approaching the end of our hour. Let me just see if we have any questions at this point. No questions. I guess I selected correctly to not solicit questions at the outset. Larry, would you be willing to come back to us and talk to us a little bit more in the future if we have a round two of this?
I'd be delighted to do so, and thank you for the opportunity to discuss amicus practice, and I hope that all of the viewers, either live or those who might view it on demand, find your questions and my answers to be of interest.
I'm going to squeak in one last question here to make sure that we don't let people fall off too soon, and that is, as a general matter, are the amicus briefs that are filed at the appellate level more important in your experience, or less important than those filed at the Supreme Court level? I mean, we certainly know the courts of final resort, et cetera, but it seems that I think when we say more or less important, I mean more or less effective.
I'm going to have to say that they're equally effective. As I've mentioned, amicus briefs supporting cert petitions are important in getting the U.S. Supreme Court to take a case. I believe that amicus letters are also important in the California Supreme Court. The fact that merits stage amicus briefs are sometimes cited and quoted by the Supreme Court shows that they count. For example, the Atlantic Legal Foundation represented some Nobel laureate scientists in the original Daubert trilogy of cases on the admissibility of expert testimony, and one of the amicus briefs was quoted in the Daubert case. At the Court of Appeals level, I think there are probably fewer amicus briefs filed than there are in the Supreme Court. And for that reason, I think that any individual amicus brief might have more impact. And again, as I mentioned earlier, sometimes coalitions of organizations will file amicus briefs. And just by looking at the cover and seeing who's filed, that may say something about the importance of the case and pique the interest of the court in reading the amicus brief. And I know that the Atlantic Legal Foundation, for example, sometimes will invite others to join our amicus briefs, such as the Pacific Legal Foundation or the Washington Legal Foundation or Cato Institute. And sometimes we will join their amicus briefs.
Interest. For some reason, I noted that I was muted for some reason. I'm hoping that our
And
participants.
I did not hear the last 5 seconds of what you
I think
said.
I was about to say thank you for that last bit of wisdom, which I think was very important for our listeners and viewers. With that, I would like to say I thank everyone for their attendance and their participation. I do invite everybody to visit the Atlantic Legal Foundation website and take a look at the types of briefs that have been filed. It's interesting both from a practical standpoint, if you're in the market to develop your appellate advocacy skills in amicus briefs. It's also interesting to see what types of issues and how those briefs are structured. And we are very, very fortunate to have Larry, who has joined us, as I say, as of last year with the ALF, and to have joined us today for the Beverly Hills Bar Association webinar series. So with that, Larry, I'll say Happy New Year to you. I don't think I say Happy New Year throughout the month of January. Okay, so thank you for joining us, and to all of our friends who have attended and members, a Happy New Year to you too. I hope it embarks a great year for everyone.
Thank you very much.
Thank you. Have a good one. Bye-bye.